Good morning, everyone, and welcome to the fifth and last day of our inaugural Summer Winter School on behalf of the United Nations Environment Programme and the Global Network for Human Rights and Environment. I want to welcome you all to this session, and I particularly want to welcome our three panelists. We're really looking forward to this morning's panel. It's a really kind of critical issue at the moment, and I think it's going to be a really fascinating panel. Just before we do that, I did want to remind everyone that the session today is being recorded, as you would have heard. So if you don't want your face to be seen or your voice to be seen, please keep your cameras and microphones off. We will be taking questions for our panelists today, and you are welcome to pose those questions in a couple of ways. If you would like to, you can put them in the chat. You'll see the chat function at the bottom there. Just share your questions and comments and thoughts in the chat. But we're also hoping to have some time at the end when we will take questions from members of the audience, when you can just turn on your cameras if you want, turn on your mics, and we can hopefully have a discussion. So with no further ado, I'm going to introduce our three speakers today. I'm going to introduce them all at the beginning and tell you a little bit about them, and then I'll hand over to them and they will tell us more about their work. I'm going to introduce them in the order that they're going to be speaking in. Our first speaker today is Jonas Schubert. He is a human rights officer at Terre des Hommes. He represents the Children's Environmental Rights Initiative, a global coalition working to ensure children's rights to a healthy environment, conducted under the auspices of the UN Special Rapporteur on Human Rights and the Environment, in collaboration with inter alia, UNEP, and Terre des Hommes. Jonas is a co-convener of the Child Rights Connect working group on children's rights and the environment, and he's also a member of the board of the German Association of Human Rights Organization, Forum Menschenrechte. Welcome, Jonas.
Hi, thanks a lot.
Our next speaker today is Zita Nefale, who's joining us from South Africa. Zita is the Senior Project Coordinator for the Center for Child's Law Research, Monitoring and Evaluation Unit. Zita obtained her LLB degree in 2011 and her master's degree in child law in 2016, and she's currently an LLD candidate in the area of child law. In 2016, she had the opportunity to be a researcher in the Constitutional Court under the mentorship of Justice Beston Kabinda. Recently, Zita has been responsible for coordinating the children's rights sector engagements with international and regional human rights treaty bodies. She was also involved in a global study on children deprived of liberty and a study on the impact of the Child Justice Act in South Africa. And she's currently involved in a project to assist the South African Human Rights Commission to develop an independent monitoring tool for secure care centers. Welcome, Zita.
Thank you so much, Dina.
Our last panelist today is Josefa Taoli. Josefa is an Ibaloi Kankanay Ibarot indigenous youth from the Cordillera, Philippines. She's a member of the steering committee of the Global Youth Biodiversity Network, the official youth constituency to the UN Convention on Biological Diversity. Sefa is an active advocate for meaningful youth engagement and respect for indigenous people's rights and knowledge. As part of the global network, the Global Youth Biodiversity Network, she contributes to the network's participation and advocacy in the Convention on Biodiversity processes, as well as in its efforts in developing the capacities of youth biodiversity officers working all over the world. She is also currently a graduate student, focusing her research on biocultural diversity conservation in her home region. Through her research, she hopes to contribute to the body of knowledge we can use to tackle the inextricably interconnected threats to biological and cultural diversity. Sefa is a former Indigenous Fellow under Conservation International's Indigenous Leaders Conservation Fellowship, co-chair of Youth for Territories of Life, the youth group of the Global ICCA Consortium, and a National Geographic Young Explorer. Welcome, Sefa. So, as you know, today's panel is going to be looking at children, human rights, and the environment. This is a critical moment in our histories to be thinking about the role of human rights and the environment in the present and future of children. While the traditional focus, I think, in this area has been on the ways in which children are vulnerable, particularly uniquely vulnerable to the harms of environmental impacts and human rights degradation. Increasingly, children are, and children's movements are at the forefront of protest movements, of political movements, of litigation, and of movements for change. And so we're also living in an era where children are increasingly the driving force of change. They are very important political actors in their own right. So I'm very excited about this panel, and I'm going to hand over to you, Jonas, to get us started.
Yes, thanks a lot, Dina. And I'm going to share a presentation within shortly that basically extends what you have just described in a nutshell, the different dimensions of the relationship between children's rights and the environment. But I want to kick off our discussion by raising a question, which is the following. Is the environment a crisis for you as participants? The greatest challenge to children's rights in the 21st century? Angela, would you please share the screen for people okay, I see you are already sharing in the chat, I think, a link that allows you to cast your vote on the question that I have just shared. I just want to have an initial impression of how you see and the relative weight of environmental issues related to other children's rights issues.
So maybe just to say to everyone, if you could go to www.menti.com, if you look in the chat, you'll see the link, and fill in code 33825641. You'll see the question there, and you'll be able to answer it there. Again, that code's in the chat.
Okay.
Jonas, the results are coming in, so you can go ahead.
Okay, perfect. And I think the results results that we can see here also correspond to what I'm going to say now, namely the following. I think personally, pollution, climate change, loss of biodiversity, etc., are indeed long-term threats to children's rights, although we must not forget that there are other developments, including, for example, digitalization, that represent relevant emerging challenges to children's rights too. And I guess that was also quite visible from the answers to the poll, that while many people actually consider environmental issues to be maybe the greatest or one of the greatest challenges to children's rights, we also saw that there were some people who actually said that it is not. And I think this is a very good way to look at the issue. On the one hand, acknowledging it's a huge challenge to children's rights, and at the same time also consider that there are the relevant environmental issues. Now I'm going to start with my presentation, and for that I want to share my screen. Okay, I hope you can see it. This is the question again. I'm just trying to see whether I can. Oh, okay. No, I'm not yet there. Okay, if we answer the question of whether the environmental crisis or the climate crisis is the greatest challenge to children's rights in the 21st century in the affirmative, though I think there are a couple of factors we need to consider. First, environmental issues are a very different challenge compared to other well-known children's rights issues in the context of, for example, juvenile justice, armed conflict, child labor, freedom from violence, etc. So what kind of knowledge, skills, approaches, etc. are required to tackle the issue? I think that's not a trivial question. I want to illustrate why. First, the Convention on the Rights of the Child is one of the 9 core international human rights instruments. None of these include a right to a healthy environment, and the UNCSC is actually the only international human rights instrument that refers to the environment in any significant manner in the context of child health and education. For a long time, human rights and environmental law developed in parallel. This mostly for historical reasons and because very different expert communities are involved. This is why many of us working at the interface of the two fields have taken steps to promote clarification of how human rights, or in this case, children's rights, can be applied to environmental problems. Without a proper legal and conceptual understanding of the issue, I think it will be difficult to mainstream rights into environmental laws and policies. I want to make a second point, raise a second point in this context. In my own experience, children's rights or human rights activists, scholars and lawyers sometimes struggle with the technical complexities of a vast range of environmental problems. And conversely, environmental experts often have a difficult time trying to understand the added value of a children's rights perspective. To give you a very concrete and timely example, the Committee on the Rights of the Child, the body that monitors the Convention on the Rights of the Child or its implementation, is right now considering a complaint by children related to climate change. It is the first ever case on environmental issues, while most of its members were trained in different fields. And yet it is an extremely important decision with potentially huge implications. So what I want to emphasize right from the start is that it is important to be sensitive to the specific historical, analytical, and even practical implications of looking at environmental issues through the lens of children's or human rights. On the other hand, while the environmental crisis poses a new and distinct challenge to children's rights, we also have to acknowledge that there are many links between the child rights impacts of environmental degradation and climate change and other children's rights issues, for example, child labor or conflict, and that there are common underlying matters of justice related to class, gender, and other forms of discrimination. For example, when children from low-income families live in settlements or go to schools in places that are disproportionately affected by air or other kinds of pollution. Let's now take a closer look at the relationship between children's rights and the environment. There are 2 general aspects that I want to emphasize here, and that were also referred to by Dina in her introduction. First, and to begin with, I mean, I'm going to come to that in a second. But first, and to begin with, I want to say and emphasize that the environment and the children's rights field are children's rights and the environment are different fields of law and policy, and this is for good reason. For good reasons, not every environmental problem is a challenge for children's rights, and not every child rights issue has an environmental dimension. Environmental protection, to put it short, operates with a broader concept of justice that includes humans, but also extends to animals and other elements of the natural environment. So it's much broader in this sense. At the same time, and this is my second point here, there is considerable overlap between the two fields. And this overlap is not always very well understood. I want to illustrate my points using two examples mentioned on this slide. The Paris Agreement is a treaty that lays out a framework to limit global warming. Its aim is to protect the environment. It is not primarily a tool to protect human rights. On the other hand, it acknowledges in clear fashion that parties to the agreement should, when taking action to address climate change, respect, promote, and consider their respective obligations on human rights, including the rights of the child. The Paris Agreement also specifies the need to ensure public participation and access to information in the climate context, and these are fairly established human rights. Another example I want to mention are laws that aim to prevent the pollution of the air or other environmental media and have a direct impact on the status of the right to health, the right to development, and other children's rights. So there are clear links between legal instruments that protect human rights or the environment. Though we have to state that children's rights in particular have only played a minor role in the environmental law and policy to date. This is why many organizations working for the rights of the child, including mine, have started engaging at the Climate COP or the negotiation or implementation of other environmental agreements and laws to draw attention to the relevance of children's rights in this context. Let's take a look at the other side of the coin, the blue one, the blue circle here, which represents the children's rights field. I've already mentioned that the UNCRC includes some references to the environment. At the national level, we can see that some states have included environmental rights in their children's laws. This has happened mostly at the level of in Latin America. Sometimes these laws refer to the right to a healthy environment if it is also constitutionally recognized. We also often find specific references to environmental education and statements of environmental duties alongside rights in such legislation. However, many countries do not have legal provisions in place that would link children's rights or children's affairs to the environment. And I think this is an area for advocates of children's rights to look at if they want to promote the mainstreaming of children's rights in the environmental context in a more systematic and structural way. Then how do we describe the overlap of or relationship between children's rights and the environment in more concrete terms? I think we can say that there are two main dimensions to it. The first one is illustrated by the newspaper snapshots on this slide. Children depend on a healthy environment to be able to realize their rights. Environmental harm can negatively affect a wide range of children's rights, often several rights at the same time. It can even impede the implementation of the UN Convention on the Rights of the Child as a whole, as the Committee on the Rights of the Child, its guardian, has repeated many times. There are direct impacts on the right to life, development, health, including mental health, food, water, and there are more indirect effects that can relate to the social or cultural costs of environmental issues. The slide here, for example, refers to a report by Human Rights Watch describing child marriage as a way for parents to cope with the impact of climate change. There are also the long-term impacts related to the freedoms and human rights of children over their entire lifespan. A very recent decision by the Constitutional Court of Germany, for example, and this is where I'm based, that's why I'm mentioning it, made it clear that the costs of climate change, mitigation, and adaptation should not be shuffled off to children and young people as future generations. The court spoke of intertemporal freedoms in this respect, applied to the context of human rights and climate change. There's a second dimension to the relationship between children's rights and the environment that is equally important and sometimes even a precondition for the first one. Children need to be able to exercise their rights to protect the environment and assert their rights as well as duties in the environmental context. The most visible expression of this is the increasing number of cases related to climate change or other forms of environmental degradation brought before national, regional, and international human rights bodies and courts by children and youth themselves. Translated into human rights language, we talk about children exercising their rights to access justice here. Other relevance apply in this context too, including the rights to freedom of expression, association, and peaceful assembly, the right of children to be heard, the right to information and education, all of which matter in the environmental field. I think it is especially in this respect, in respect to the second dimension of the relationship between children's rights and the environment, that the discourse about children's environmental rights takes on a broader meaning in the sense that it can help vindicate children's participation or civil and political rights more generally, rights that are still often denied to them and questioned by adults. The next slide summarizes the relationship between the UNCRC, or the UN Convention on the Rights of the Child, and environmental protection. The UNCRC is a very solid legal basis to establish links between the two fields of law. It includes many rights that can be adversely affected as a result of environmental harm, and it contains rights that ensure the empowerment and participation of children in environmental matters. I want to raise a couple of additional points that refer to relevant legal aspects of the relationship between children's rights and the environment. Traditionally, children's rights included in the convention have been categorized along the lines of protection, participation, and provision. While it can be discussed whether the categorization makes sense, or if we should better say that each child right or each human right includes all three aspects, we can certainly state that the environmental context has implications for all of them. If we take provision as an example, not discussed so far, it is pretty obvious that children will not be able to realize their rights in the environmental context unless states put in place certain measures to ensure, for example, sanitary conditions through waste management, etc. So this is an example of how provision rights become relevant for children's rights in the environmental context. We know that rights correspond to states' duties. Otherwise, the legal concept of human rights would appear to be toothless. The human rights discourse often distinguishes between obligations to respect, obligations to protect, and obligations to fulfill. Again, all these duties apply when triggered as a result of the impact of climate change or environmental harm on children's rights. In other words, states should not themselves harm the environment in ways that interfere with children's rights. They should not, or they should protect children against environmentally harmful activities of third parties, including the business sector, and they should put in place legal frameworks and institutions that help protect the environment for children. I want to highlight another aspect of duties in the environmental context. States have the duty to take additional steps to protect groups in vulnerable situations, including children. That's established human rights law as the framework principles on human rights and the environment developed by the former UN Special Rapporteur on Human Rights and the Environment, John Knox, clearly demonstrate. The duty to apply heightened obligations can be applied across all sets of rights, children's rights, participation, protection, and provision rights in the environment and in the environmental context. All of the conceptual reflections that I've shared so far could be subsumed under a child rights-based approach to environmental protection and have been addressed to varying degrees in recent years by relevant experts and institutions of the UN. In 2020, for example, the UN Human Rights Council passed a resolution that summarizes much of what I've just said in a very compact form in a resolution, and I suggest that you take a look at it if you want to learn more about the relationship between children's rights and the environment and and the points that I've just shared. Next, I want to draw attention to the right to a healthy environment itself. What you see here is a call of now more than 2,000 organizations worldwide for the UN to recognize the right to a healthy environment. The right has been recognized at different regional and national levels, but it has never been formally endorsed as a human right by the United Nations. Such a step, I think, would be of particular importance to children. The right to a healthy environment is closely connected to children's rights already included in the Convention. And it might be argued, I think, that it can be derived from the Convention. At the same time, the right to a healthy environment, includes a lot of aspects that provide maybe more direct and immediate protection of our entitlements to environmental quality. So, for example, if we take a closer look at the right, it has a special connection to the connection in the sense that if we take, for example, the right of children to play in non-toxic environments, I think it is clearly visible why the right to a healthy environment is closely connected to children's rights. Or if we take a look at strongly health-related aspects of clean air in relation to Article 24 of the Convention on the Rights of the Child related to the right to health. So we see that there's a clear link between the right to a healthy environment and the Convention on the Rights of the Child. At the same time, I feel there are aspects of the right, and these aspects that I mentioned here have been defined by the current UN Special Rapporteur. There are aspects to the right that are not as clearly established in the Convention on the Rights of the Child and would benefit from the recognition of this right. For example, the right to have access to healthy ecosystems and biodiversity, or the right to live in a safe climate. I think the right to a healthy environment would provide very direct protection of these rights. Finally, I want to highlight two concepts that are strongly related to a child rights-based approach. Given the very worldwide trend that activists standing up for environmental and land rights increasingly face threats and persecution, there have been a lot of efforts, including by the UN Environment Programme, in recent years to protect and strengthen their work. It is important to emphasize, in my view, that children and young people can be affected by this phenomenon too. To illustrate my point, I want to mention a couple of examples that have arisen as part of my work. Two well-publicized cases: a young Indian environmentalist and Fridays for Future founder in India, Disha Ravi, who was jailed recently for her campaigning in support of farmers who are opposed to agricultural marketing laws. And the 11-year-old Francisco Vera from Colombia, who received death threats due to his social media activities related to education and climate change. Then there is a not so well documented case of an adolescent involved in one of our partner projects who spoke out on TV against pollution as a result of a local mining project and was sued for libel by the responsible company for it. I'm also aware of the increasing threats threats against and ridiculing of young female climate activists, often online. And this is something that I see a lot here at the German level, for example, often by right-wing and conservative media or right-wing parties. And I think that's a real problem, often faced by young female activists. While the risks and dangers of adult defenders of the environment have received a lot of attention in recent years, the situation and needs of young activists are not as well understood in my experience. Terrorism and its local partner organizations, Terrorism is my own employer, are right now implementing a project that aims at gathering quantitative and qualitative data on specific threats faced by young environmental rights defenders in Colombia with a view to developing specific protection guidelines and tools. This is just a very concrete example of how we are trying to address this gap at the project level. There are two further points that I want to raise in this context. First, we need to understand that children do not only face threats as a result of their environmental engagement, they are put in a more disadvantaged position right from the start, as they are usually not recognized as right holders. They do not have access to readable information. They are not included in decision-making about the environment. Second, the concept of children or young environmental rights defenders has a positive potential and can be used in an empowering way to show that children have participation rights just as everyone else. The concept of environmental justice does not originate in the concept of human rights. but it is strongly linked to it. It points to the fact that there are some segments of society that are more affected by environmental harm than others, and that there are inequalities between countries too. The non-discrimination principle captures the idea in human rights and language. The idea of justice is one that plays a strong role, for example, in the actions of Fridays for Future, and here often refers to intergenerational equity. We also see that children from low-income families, indigenous children or girls, are often disproportionately affected as a result of environmental harm. So these are two examples in which, for the way in which environmental justice and human rights interrelate. When we consider the relationship between children's rights and the environment in international law, we need to be mindful of the fact that many progressive developments are still very recent. It is in an area that has gone from agenda setting a couple of years ago to a stronger focus on standard setting, capacity building, and tools right now. One of the areas that we focus on in our own work is standard setting. The reports of several UN special rapporteurs related to human rights and the environment and with a focus on children's rights help lay the groundwork in terms of the normative and conceptual understanding of children's environmental rights. I've already mentioned the Human Rights Council resolution on children's rights and the environment as an effort to standardize. There are also regional efforts, as in this case, as in the case of the ASEAN principles and policy guidance, for example. I want to draw attention to a very important development that is of recent nature. The UN Committee on the Rights of the Child, the global guardian of the UNCSC, has just decided to write a general comment, a legal commentary to guide states parties when they implement the Convention on the Rights of the Child in the climate and environmental context. I would really encourage you to follow this process, which is going to be rolled out over the next year, as I think it will break new ground in terms of strengthening children's environmental rights internationally. My presentation so far has mainly focused at developments at the international level, which are the focus of my work. This should not be understood in any way as suggesting that there are no relevant developments at the regional or national levels. I have already mentioned, for example, the ASEAN guidance on children's rights and the environment. I've also mentioned the environmental rights provisions in national children's laws, or the increasing number of legal cases brought before national courts. With the Children's Environmental Rights Initiative, we are currently working on a child-friendly version of the regional SHRE agreement for Latin America and the Caribbean on access to information, participation in decision-making, and justice in environmental matters. There are also countless initiatives and processes going on at the national level. Because I'm from Germany, I just wanted to refer to one example concerning my own work. The Children's Commission of the German Parliament recently held its first ever series of hearings on environmental issues, including the right to a healthy environment, on which I spoke. The series of hearings will result in concrete guidelines to mainstream children's rights in environmental laws and policies at the domestic level. Such processes, I think, are going on at the moment in many different places, and I encourage you to look at your own country and identify what steps are being taken at the national level to strengthen children's rights and the environment. My last remark. Already pointed to the following. We should not forget that the children's rights approach to the environment only matters insofar as it can be applied in practice. This requires tools and instruments that translate words into measures, and many actors in the children's rights field have started developing such tools for various purposes. I have included some potential implementation measures here on my slide for the sake of illustration. So, for example, something that many partner organizations I work for consider as very relevant is the development of a child rights-based environmental impact assessment, because many issues related to the environment concerning the local level are huge infrastructure or development processes, and here it is important to assess their potential impacts and include a child rights perspective. And so there are many other different examples of the way in which the children's rights approach can be applied in practice. I just want to refer here to another example, the Paris Agreement. I think the Paris Agreement provides a real opportunity for integrating a rights perspective, because it is the first global environmental treaty that actually mentions the human rights obligations of states, and I referred to it earlier on. And it mentions children's rights. The Children's Environmental Rights Initiative, the platform that I represent here today, launched a declaration on children, youth, and climate action at the last COP25 in Madrid. That declaration spells out 7 commitments that states should make in order to implement their children's rights obligations under the Paris Agreement, related, for example, to the mainstreaming of children's rights in all climate actions, including mitigation and adaptation, climate finance, climate empowerment, education, and participation. This is just, and I come to an end, this is just one example of how children's rights actors are now trying to build a bridge between the concept of children's rights and the environment and implementation in the practice, implementation and practice. I think we are going, and we need to see, we're going to see, and we need to see many more of these initiatives as we move forward. I conclude by raising a couple of open questions and challenges that we need to address in the future. As I mentioned before, there is this initiative for the UN to recognize the human right to a healthy environment. And I think as children's rights activists, we have the responsibility to spell out what this means for children. What does it mean to implement the human right to a healthy environment for children? I think there's a lot of work to be done in this respect. There are a couple of rights issues that I think we need to address. So, for example, collective rights play an important role in the environmental context, but so far they haven't played a huge role in the context of human rights more generally. But I think environmental issues often affect large groups of people, or many groups, or the population at large, and can only respond to in a way that looks at people collectively. So I think there's a strong reason here to strengthen the role of collective rights and not just think of human rights as individual rights. There's also the importance to look at the role that environmental responsibilities and duties of children could play. Usually, children's rights activists are a bit reluctant to speak about children's duties if their rights are not recognized in the first place, right? So if you look at the Convention on the Rights of the Child, for example, you don't find any specific references to duties. You find references to the aims of education in Article 29, including the aim to prepare children for a responsible life in a free society. That's a very light way to express that children assume responsibilities as they grow up. I think that's a very good way to phrase it, and it is relevant to the environmental context as well. But I think I want to emphasize the following point. You can say that children have environmental responsibilities, but you also have to give them the opportunity to participate at the same time. So unless they have the right to participate, the right to access their freedom of expression, etc., it would be unfair to say that they should also assume environmental responsibilities. Then there are a couple of further points I mentioned here. One is the anthropocentric nature of the human rights concept. So often environmentalists say that that we should actually not speak about human rights to have the environment, but the human duty to protect the environment, and that the anthropocentricity of the human rights concept actually adds to the problems related to the environment we already have. I think there are many ways in which we can respond to that. One is to say that human rights can actually help to protect the environment. So if we protect environmental rights defenders, or if we protect the exercise of rights related to access to information, participation in decision-making, and access to justice, that would very much help the protection of the environment more generally, because often these access rights, the access to information, for example, does not just apply to a situation. So it's situations where people are affected themselves, but can also be claimed in cases where the environment is affected more generally. The last 2 points here refer to the following. We right now in our work, we look a lot at standard setting, and I think this is also important because the environment is an emerging children's rights issue, and while in many other cases related to children's rights, we already have strong standards. This is not the case here in the environmental context. So we have to push for strong standards that can then be applied by states and other actors. At the same time, we should not lose sight of the fact that these standards should be implemented. And this is an area that where environmental laws have a lot of problems. So while we have standards, laws, etc., a lot of laws in the environmental context, these are often not implemented. And so we also need to concentrate on the ways in which a child rights-based approach can be applied in environmental practice. Lastly, I want to say we need to focus on building the capacity of children's rights activists working on the environment, simply because this is not an area where children's rights experts have focused, that children's rights experts have focused on in the past, and they often lack the expertise to address the issues. And the environmental community is often working differently with different tools and different areas compared to the environment and through the human rights or the children's rights community. And I think we have to build bridges. I stop here, and I'm saying sorry because I think I have actually spoken a lot already, and I want to leave enough space and time for the other two speakers. Thanks a lot.
Thanks so much, Jonas. That was really fascinating and has raised kind of many interesting points that I'm going to stop myself from talking about right now. I'm going to hand over to Zita, but I think there's going to be lots for us to talk about in the next session. Well, Jonas has given us a very kind of good sense of some of the big issues at the international level. He pointed to initiatives and developments at the regional and national level, and I think Zita is going to pick up from there and sort of take a more regional look at this issue. Over to you, Zita.
Thank you very much, Dina and Jonas. I'm going to start sharing my screen before I get into anything. Can you see that?
Yes, that looks good.
Okay, thank you. Yeah, so I think I'm going to be sort of carrying on from what Jonas has presented on, a very interesting presentation, and sort of drill down into emerging practices to ensure the advancement and protection of children's environmental rights. And as Dina has indicated, I'm going to look at regional perspective and link it to the practice of strategic litigation. So an emerging practice of strategic litigation on children's rights, environmental rights in particular. So I think my starting point is to quickly go through terms I'm sure you already know, such as access to justice and strategic litigation, and linking those to discussion on environmental rights, children's environmental rights and human rights. So access to justice is access to just and timely remedies, or the ability to obtain just and timely remedies for rights violations through the use or the basis of international human rights instruments as well as national legal frameworks. And the access to justice has been seen as a fundamental right in itself, as well as an essential prerequisite for the protection and promotion of human rights, including children's environmental rights. Now, linking strategic litigation to access to justice, strategic litigation, at least the Center for Child Law has been using strategic litigation as a way to facilitate children's access to justice. So it can be a powerful tool. It is a powerful tool to ensure children's access to justice, to ensure that children have access to relevant and timely remedies for rights violations. And strategic litigation, very briefly, is the process of selecting and bringing a case to court with the goal of creating broader change in society on selected issues. Now, the practice of impact litigation or strategic litigation is developing and growing to varying degrees on the African continent. So you'll have countries like South Africa, Kenya, Malawi, Zimbabwe, carrying out strategic litigation more regularly than other countries where this is a practice that is growing and they are learning. And this is all very much dependent on the type of legal system that is in place and how that legal system would interact with such levels of litigation, and then litigators determining how then best to carry out impact litigation in order to ensure effective change. Now, examples of how the Center has used strategic litigation, the Center and other organizations, is to firstly ensure broader access to education for vulnerable and marginalized children. So we have done litigation on quality of education, access to education, affirming the rights of children in conflict with the law, protecting the identities of child victims, witnesses, and offenders, and looking at the rights of children in the care and protection system. And this is all to say that strategic litigation is a tool that has been successfully used to affirm, protect, and advance children's human rights. And the same can be done for children's environmental rights. Now, in the South African context, impact litigation to advance children's rights is quickly emerging as a ripe issue for litigation. Now, that's not to say that litigation on environmental rights has not been happening at all. When you look at work that's been done by the Center for Applied Legal Studies, the Center for Environmental Rights, and other human rights bodies, you will notice that there has been a history of litigation on environmental rights broadly, either to hold the state to account in their duties to ensure reduction of levels of pollution, or to hold corporates to account in their duties to ensure that their activities are balanced out against the environmental rights of persons living in communities. However, the practice of now looking at children's environmental rights in litigation is something that's emerging quite quickly and is quite a significant issue in the times that we are living in. An example that I will give is a case that is being led by the Center for Human Rights, Groundwork, and other organizations, where they are holding government duty bearers to account. And this is a legal challenge where the groups argue that the unsafe levels of air pollution experienced by families and children in the Mpumalanga area are a violation of South Africa's constitutional right to a healthy environment. Now, this case impacts everybody living in the Mpumalanga area, the high-veld, what has been declared a high-veld area. And the pollution comes about as a result of a number of coal-fired power stations, as well as mines, resulting in large volumes of pollution and producing pollutants linked to asthma, cancer, heart and lung ailments, and other health issues. But what is important about this case for children's rights is the arguments being made specifically linked to the child's best interest. So in addition to saying everybody in the communities are affected by the actions of the coal mines and related activities, the justice groups also argue that South Africa's constitutional requirement that the government give the child's best interests of paramount importance is in every manner means that by failing to reduce air pollution, the government is not meeting this legal obligation, and that the harmful levels of air pollution can never be in a child's best interest. So now there is the element of the child's best interest being brought into the case and arguments being made around that. In addition, the UN Special Rapporteur on Human Rights and the Environment has come into the case as a friend of the court or as amicus, and has warned that a failure to protect children from air pollution violates South Africans' obligation under international human rights law. He notes that children have their whole lives ahead of them, making irreversible health impacts especially devastating for them. So what this case is looking for is for the duty bearers, government duty bearers, to actively monitor and implement plans that they have put in place, where they say that they will manage levels of air pollution. And the case is saying, well, the government duty bearers have not done this enough, therefore they are being held to account in this duty. So one of the cases that the Center for Environmental Rights is bringing, and the Center for Child Law is supporting them in terms of advocacy, and we are engaging with them on carrying out research to, again, specifically focus on the impact of children, and then look at how we can further carry out litigation to advance children's environmental rights. Looking at the wins and successes that we have had with previous litigation efforts. Now, I'm hoping I'll be able to play you a video just to indicate how this case is important for children's rights and children's well-being in particular. So let's see if it's going to work out for me.
I don't think we're hearing it, Zita. Zita, we're not hearing any sound. Should we be?
You should be hearing sound. Let me try again. If not, then I'll just move on. Well, let me move on. I'll share the video, the link to the video with the participants, but I'll move on. So the aim of the video was just to show how this litigation is important for children living in the communities. Now, when one looks at litigation in the South African context and in context of other countries as well, it's always important to look at what hinders or enables impact litigation, strategic litigation. So one would have to look at justiciability of rights. So the rights that are set out in the national legal framework of a country. Can a person approach a court, a person whose rights have been infringed, bring a case to court and say, my rights have been infringed in this manner, and I would like to obtain some form of relief. Then the next issue that one looks at is separation of powers. And this is a crucial factor to assess because it provides a sense of how much power the courts have and how far they will be able to exercise their power in relation to entering into the arena of other spheres of government. Now, in a country where the separation of powers is strictly adhered to, judges may be reluctant to step outside of their own sphere. In a country where it is not, where it is little adhered to, for lack of a better word, the courts may lack any real sway. So now the question then one will have to be looking at is, are the judges sufficiently independent from other spheres of state to make orders that must be carried out by them? And this is something that, a question that we are engaging with colleagues in other African countries, depending on the structure of their legal framework, is how much power do judges have in different contexts? So in the South African context, for example, the way the law is structured is that, yes, there is separation of powers, but when government departments or government duty bearers have failed to act in a manner that is protective of human rights and in a manner that ensures that they are carrying out their duties, then courts can come in and say, you must do 1, 2, 3. And we're seeing this in other countries like Kenya Zimbabwe. So it depends on, again, legal framework. The other issue that, again, one has to be looking at is standing, and this the ability to be able to bring a matter to court. And this is specifically important where children litigants are involved. So one has to decide, depending on the case, safety of children, how children want to voice their issues, how the issue of standing is going to be dealt with. Often we have been able to go to court representing particular groups of children or representing organizations that work with children, depending on the issue. Other issues to be looked at is a strong child rights civil society where they'll be able to support litigation being brought, as well as the international and national legal framework. Does national law provide for protection of environmental rights? How does one argue that in court if it's not explicitly in the national law, but it is in international law that has been ratified? So then thinking around that, and then the court's powers. So what powers do the courts have? And this brings us to the case of the children of GNHRE. And this is quite close to my heart because this is a case involving children in Zambia, so in the GNHRE district of Zambia. So a class action has been filed against Anglo America in South Africa. In the South African High Court on behalf of a class of apparently estimated 100,000 individuals in the GNHRE district who are believed to have been poisoned by lead. The application is brought by 13 plaintiffs on behalf of children under the age of 18, as well as girls and women who have been or may become pregnant in the future. Now, the action focuses mainly on the fact that children are suffering from alarming levels of lead poisoning, which, depending on various factors, causes a range of significant conditions from psychological, intellectual, and behavioral damage to serious physical damage to their body organs and neurological systems. Now, what is being asked is corporate responsibility, right? So the class action seeks to pursue remedies in the form of compensation for the children, as well as the girls and women who have been affected by lead poisoning, and also seeks blood screening for the children and the pregnant women in GNHRE, and also cleanup and remedial action of the area to ensure the health of future generations of children and pregnant women is not jeopardized. So the deadly air case is looking at the responsibility of government duty bearers to hold corporates to account, to monitor the actions of corporates. And this Children of GNHRE case is looking at corporate responsibility, so the responsibility of corporates in the spaces that they are working. Now, another important issue that's going to come out of this case and is going to really hinge on courts' powers is the jurisdiction. So the matter of jurisdiction, the fact that the matter is being heard in a South African court because Anglo-American has a division in South Africa, but the matter, the plaintiffs and the community affected are based in Zambia. So again, it's going to be what the outcome of this case, hopefully, working in favor of the plaintiffs, is going to be important for issues of jurisdiction and the fact that environmental harms are broad, and therefore we cannot be limited in jurisdiction and cannot be limited in the sort of remedies that one seeks. So then what can courts do? These are just a few of the things that courts can do, and these don't stand alone, they often work together. A court can give a declaration of rights, declaring that these are the environmental rights, right to a healthy environment, right to a healthy well-being that children have. Courts can thereafter come and declare that law or policy or conduct is unlawful. The policy of the government department in not holding people in corporates in a particular area is unlawful and should be amended in this way, or the conduct of a corporate in itself is unlawful, or the conduct of a government in itself is unlawful. So after we have declared these rights, we are declaring this law, policy, or conduct unlawful. We could have interdict or mandatory relief, where we're saying, where a court is saying that corporates are interdicted from carrying out certain actions, or government duty bearers are required, are mandated to carry out certain actions in order to provide appropriate relief. And what has really worked out for us is structural interdict in order to ensure that us as the litigants are monitoring implementation of court orders that we have received. And we're hoping that this is something that we can bring into environmental rights litigation as well, where a court is going to give a court order, a judgment, and say, this is what must happen. This corporate must ensure a cleanup of this area, must ensure access to health services for children who are affected by mining, and it must happen in, the cleanup must happen within a 5-year period or a 2-year period. And the Center for Child Law or another organization in another African country should be able to follow up every 6 months by receiving reports from the corporate or from government every 6 months, and responding to those reports through the court structures, right? So this has helped us track implementation of court orders, and also to be able to go back to courts when we notice that implementation is substandard or underwhelming. Another important thing to remember about litigation is that litigation is no lone wolf. Litigation alone won't change practices, laws, and policies. You will receive a court order, but a court order is just on a piece of paper. Other things must accompany the court orders. And again, this is why talking to communities in African contexts, in African countries, and as well as communities elsewhere is important, because you're looking at social movements. So how will the groups ensure that the right information is given for litigation? How will the groups ensure that the outcomes of litigation are implemented? So social movements, people on the ground are there to ensure that things do change. Advocating for changes to law and policy. So when somebody receives a judgment or a court order, advocating for that change now to the law or policy must happen either in parliament or in government departments. Working with media to influence public opinion and change narratives. So working with media to educate, to bring light to issues, public education as well, follow up to ensure implementation of court findings, and learning from others. So litigation itself, a court order and a judgment itself will not change things. And sometimes litigation may not be enough. So once one has exhausted all of their, what we call internal remedies, domestic remedies, and they believe that they haven't gotten the sufficient assistance or relief that is needed, then one can approach Committee on the Rights of the Child, or in the African context, the African Committee of Experts on the Rights and Welfare of the Child, to argue for the relief that is sought. Thank you very much.
Thank you, Zita. That was incredibly fascinating. Such a kind of useful overview of litigation as a particular tool, but also to some of the regional instruments and possibilities, and some of the litigation that's happening in South Africa and Africa more broadly. Thank you. Over to you, Sefa.
Oh, thank you so much, Nina, and thank you for the opportunity to join you today. I did want to start by playing a song. I hope it works. And yeah, before I start my presentation, just 1 second. I hope you can hear it.
Remember your children, remember our future, remember your children.
Yeah, thank you. I hope you like that song. Again, my name is Sefa. I'm an indigenous Ibalay-Kankanay-Igorot from the Cordillera region in the Philippines. I'm talking to you from Baguio City in the Philippines, which is just part of the ancestral lands of the Ibalay people. And yeah, I just wanted to play that song, which is a song from here where I'm from. I actually come from a family of indigenous people's rights activists, and this is a song that I've been taught since I was young, written by my aunt and sung by my cousins actually, and it's a song that's still taught today to many children. And as you kind of might just 1 second. Yeah, as you might imagine, the context of where and why that song was written. As you might imagine, here in our ancestral lands, we are facing a lot of these big industries being imposed on the communities, like mining or plans for dams or deforestation. And it's something that's affecting our nature, and it's compromising the future of young people in our community as well as future generations. Here we call it development aggression. So yeah, I just thought it would set a good context for what we've been talking about in this session. And to jump right in, I'm going to be talking about some aspects of children and youth as political actors. And so just to start, Jonas already provided a great context about this, but just to again say that children and youth are among the most vulnerable groups to environmental harm. We're more susceptible to negative health effects of pollution and unclean water. We will be living with the long-term consequences of environmental harm, and we're very often tokenized, marginalized, and excluded from environmental decision-making. But not forgetting also that children and youth are obviously not a homogeneous group. We're not monolithic. We are diverse, and our issues are intersectional. Young girls, young disabled persons, young refugees, young persons living in poverty, young members of the LGBT community are further impacted by environmental harm. In particular, for example, some of the challenges faced by indigenous children and youth are things like political instability, militarization of our communities, urban migration, lack of access to culturally appropriate education, the erosion of our indigenous languages, continued discrimination, continued criminalization, harassment, and killing of environmental defenders, many of which are young people, and continued development aggression and disrespect for our rights to land. For example, just last week, a very tragic story from here in the Philippines. The Philippine Army actually shot at 3 indigenous individuals from the Lumad Manobo tribe while they were harvesting abaca from their farm, and one of whom was just 12 years old. So these stories have, unfortunately, they really have been increasing in recent years with the rise of many authoritarian governments in many countries, including mine. So just to also kind of say that it's important to be aware of the vulnerabilities, but we need to remember that these groups are being marginalized, but we don't belong in the margins. We're very much central to achieving the future that we want, and quite often, we're not inherently vulnerable, but being made vulnerable by very unfair systems. And so it's good to remind ourselves not to internalize these terms of marginalized and vulnerable as women, as indigenous peoples, as youth, because we're not, we're central, and we're powerful in fighting for a better planet. Just to say that children and youth are a very creative, passionate, solutions-oriented group. We are often on the front line of movements for the environment, and there's no doubt that throughout history, young people have participated, have contributed, and have catalyzed many important changes in our political systems. And therefore, our rights must be respected, and our needs, our perspectives, priorities must be considered in the decisions that affect us. So speaking a bit to my own experience, as I said, I'm part of the Global Youth Biodiversity Network, or as Dina mentioned, which is a global network of young people that are taking action for biodiversity on the ground and also in policy. We represent the youth voice in the UN Convention on Biological Diversity. We do this especially now in the context of what they're calling the super years for biodiversity, where world leaders are currently in the process of negotiating a global framework to revert the loss of biodiversity and to move towards living in harmony with nature. And they're calling this the post-2020 Global Biodiversity Framework. And in these spaces, what is it that young people are calling for and are demanding? Well, young people are calling for, genuine transformative change that we now know we need to live in harmony with nature. We're calling for the addressing of the root causes, really, of biodiversity and cultural diversity loss. We envision a future where there is the integrity of our life support system, like life in its broader sense, including not just like being alive, not just biodiversity, but also cultural diversity, and something discussed in one of the sessions yesterday, like the living with dignity, right? We envision a future where society is living sustainably and where there is this shift in values and principles to actually address the root causes, and a world where there is equity for nature and people, recognizing that equity and the fight for the environment are largely, part of the same fight. What have we been advocating for as young people? We've been advocating in these spaces for intergenerational equity and the full and effective participation of youth. We've been calling for transformative education. Like, many young people believe that the education that we have right now is nowhere near what we need to actually catalyze this transformative change that we need to address biodiversity loss. And we have been strongly advocating for rights-based approaches for people and nature, and rights-based approaches to conservation, right? Just an example, some weeks ago, we launched our Stop the Same campaign because we're just tired. We're tired of the same broken promises, the same excuses, the same greenwashing that's been happening. So yeah, this is some of the things that we have been advocating for in these spaces. In other words, same sucks, we like to say, and biodiversity rocks. So those are the things that we as the Global Youth Biodiversity Network have been trying to advocate for to the best of our ability at different levels, despite many challenges, which I'll be speaking about in a bit. But it's also, of course, really wonderful. This is how we participate in terms of policy advocacy, but young people are taking action in so many diverse ways, all fighting for a fairer, more sustainable, more equitable world, right? Indigenous youth are on the front lines of so many fights against many instances of environmental destruction. We take to the streets and protests. We bring these issues to courts. As Dita also mentioned, we try our best in the policy spaces where youth voices are very heavily in the minority. We build our own capacities and learn from each other. We do so online or through things like art and music and literature. And really importantly, we do so by taking action on the ground where it matters so much. But there are a great many challenges to being able to participate meaningfully. So I'll just speak to some of them. So first is the individualization and tokenism that's been happening. We probably all know Greta and the many climate movements happening, and her work and everyone's, all these young people's work thus far has been mobilizing immense attention for youth and have been really, really valuable and admirable. But just to say that kind of a side effect that has been happening is that more and more people are wanting to involve young people, but they are not doing so in a very meaningful way. And it's causing increasing instances of youth tokenism or youth washing in a way, where involving young people has been very superficial. Like it's being treated as a PR stunt, like it makes them feel good without really making any lasting impacts. And young people end up feeling belittled and powerless and underinformed to actually participate. Like just an example, once I was invited to a consultation by a big conservation organization on their document on environmental education. But at that stage, the document was already almost final. It was written in large part by adults. We weren't informed of how our inputs during the consultation would actually feed into the document. And so, yeah, these things end up becoming really frustrating, and you feel kind of used when there wasn't really any meaningful consultation. The second, individualization, meaning like there's this rise of individual superstars, I suppose, in terms of activism, which is valid, but sometimes could undermine like the more democratic ways that young people organize ourselves. More challenges are that like there are no resources being allotted to engaging youth, sometimes even charging young people to participate, which of course privileges some youth over others. There are regressive narratives, like instead of focusing on young people and the obligations of states to realize the human rights of young people, the narratives have been pushing towards more like young people as being a good economic investment, for the systems that are already kind of unfair. We lack access to youth-friendly information. We are often kind of seen only as beneficiaries rather than having the capacity to lead our own projects and make our decisions ourselves. Too often we're not seen as really whole people, and again, we're underrepresented in decision making, and the mechanisms to participate are often unfriendly or hostile, right? So for my last few slides, I just kind of wanted to leave everyone with some insights on what we can do to actually move toward meaningful engagement of young people, which we might be doing in our different contexts and experiences and work. For example, one tool that we found quite helpful in this regard, if you haven't heard about it yet, is Hart's ladder of youth participation, which kind of describes different levels of decision making, of agency and control that can be given to children and youth by adults, with the bottom rungs being the most exploitative and most the least meaningful ways of engaging young people, and at the top are the most meaningful ones. So you can see that like at the bottom, you have young people are being manipulated, they're being used as decoration, they're being tokenized. These are forms of non-participation. And then kind of going one step higher, you have young people being assigned roles and informed of their role, being consulted and informed, and initiatives that are initiated by adults, but they share decisions with young people. And at the top two rungs, you have young people being able to lead and initiate action, and even and sharing decision making with adults in youth initiated spaces. So this has been kind of a really helpful tool. I'll try to move. I'm on my last few slides. There have been, for example, principles for meaningful youth engagement outlined by the UN Major Group for Children and Youth. Things like being self-organized and ensuring young people have the autonomy to decide on their own, like their structures, their ways of working. It needs to be legally mandated, part of the rules of procedure of these kinds of processes, designated, where young people should be made to compete for space, to speak, well-resourced, because participation is a right, it's not a privilege, and accountable with ways to actually provide feedback and and act on it. So not just last two slides, some ways to avoid tokenism and being complicit in tokenism is being specific about the structures that your organization wants to create. Sometimes if you have very vague ideas of what you want to do with young people, it becomes more tokenistic. It has a bigger tendency to become tokenistic. Another is to remember that one young person doesn't represent youth at large. Being careful with consultations, as I already kind of mentioned. It's to remember to ask questions and accept feedback from the young people that you are engaging. Being aware of who speaks in meetings. Sometimes these spaces are very intimidating for young people to actually bring forth what they think, and to involve young people as early as possible in projects, in budgeting, and in program design. And just the last kind of note on Indigenous youth who are inheriting the responsibility, this very big responsibility to protect and preserve the traditional lands upon which our cultural heritage and our identity is based. Indigenous youth face many challenges, which I described earlier, which deserve attention. But also, like, I really believe that Indigenous youth can lead the way to addressing many of our most systemic problems, guided by kind of the Indigenous values that we have been brought up with. So I think I'll end my presentation there, so there's some time for discussion, hopefully, and thank you so much for the time.
Thank you so much, Sefa. That was really fascinating. And I think bringing just both kind of an intersectional point of view, but also sort of thinking about kind of really meaningful tools for youth engagement is just an incredibly valuable contribution and a really great way to finish our presentation. So thank you very much. Thank you to all our panelists. I know that Jonas has to leave in a moment or two, so maybe we can start with a question for you, Jonas, if that's okay. It's a question about agency. So one of the things that your talk sort of pointed to in a way is that there's kind of an initial problem before thinking about the ways in which children are sort of affected and are themselves rights holders and are themselves activists. There's kind of a misrecognition in the law, in international law, in domestic law, of children as agents. Their agency is not recognized, and Zita pointed to this as well when thinking about sort of problems of standing, and often children are not recognized in law as kind of full agents, as full persons, even as a mechanism of protection. This is meant to be to sort of protect them from the burdens and responsibility and sort of even sort of violence of the law. So I guess the question that I have for you is, how do we think about, how do we kind of reach a good balance between agency and protection? How do we balance participation and leadership and engagement by children with the need to not make them sort of fully accountable in the way that law sometimes demands of legal persons?
Okay, so I'm trying to give an answer to your question. Well, I guess, I mean, the tension that you describe is one that concerns many children's rights fields in a way, right? And I'm stressing this point because I feel that the environmental context is actually one in which both aspects, or the relevant of both aspects, becomes relatively clear. So while participation in certain areas is difficult to convey to certain stakeholders, relevant stakeholders, it is easy to see why children should have a say on certain issues, simply because they have specific experiences. I mean, they interact with the environment in very different ways than adults. So we have heard, for example, from Zita, the case in Kabwe, where an abandoned lead mine is polluting the neighboring communities. I was there in the past, so I've seen the place. And so you can see a lot of children playing around this mine, using informal, let's say, abandoned areas to play. If you don't ask these children where they play every day, it will be difficult to find or identify priority areas for cleaning up the site, for example. So I think there are very good reasons and understandable reasons also for adults to actually ask children for their views on certain issues. And on the other hand, so I think it really, the environmental context is really good to see that, why it's important for their experience. And we can also see that children actually also exert influence on political decisions, right? We can see that in at many domestic levels now through Fridays for Future, etc. So my impression is that many political decision makers have actually accepted their agency in the environmental context. At the same time, you're right, of course. We must not forget that children's rights are also there to protect children from environmental harm. And this aspect needs to be emphasized as much as their agency. But I think they can be aligned in a very creative and instructive and constructive manner in the environmental context, way more than in other fields. I don't know if this is an answer, but maybe a sort of an answer.
A great answer. Thank you
Okay.
very much. I have a question from Kate McKenzie. Kate, if you're still with us, should I read the question out? Did you want to ask the question?
If I could ask, and thank you to all three speakers. I've been scribbling notes like mad. I have several people to look up afterwards, but no, I wondered, and my perspective is particularly from the UK, also as a parent of teenagers, how we can convert children and young people's commitment to the environment, which I do see and hear around me, into mainstream political engagement, particularly in terms of voting, because it's very easy for politicians to ignore young people's voice because it doesn't translate into young people voting. Voter turnout levels are much lower here among the young than they are among the old. And you can see exactly the effect of that in terms of policies. I also think, and sorry, I didn't put this in the text because it just occurred to me as you were speaking, when you think also, you look at some of the policies and the language, the discourse around COVID and COVID policies, I still don't think in the UK certainly, and I have heard similar things from colleagues in Germany, that children are really talked about and thought about as full human beings. When you have discussions about vectors of disease, or that the biggest problem in terms of children and COVID is they must catch up with their education as if they are buckets to be filled. And I see a vicious cycle in the UK in that young people and children feel turned off by mainstream politics, therefore don't engage, but that also lets the politicians off the hook because they then don't feel they need to engage with children in return. And I wonder how we translate this commitment into real pressure. I mean, is the courts the way? Is political engagement the way? Protest? Suggestions, please.
Thanks so much, Kate. Sefa, Zita, would either of you like to give a little thought to that question of how we transform the kind of energy and commitment into sort of political engagement?
First of all, I relate to that feeling. I understand why young people would be disinterested to engage, especially in systems where they feel they're not part of, or they're not being listened to. One of the things that we have been discussing in this regard has been on education. We feel that many educational systems don't really provide this kind of capacity for young people to know how they can participate, why it's important. This is a very big weakness in terms of what we learn in school. And so what we need actually is an empowering kind of education, which really fosters this kind of this kind of mindset wherein young people know and understand why it's important to engage politically and be active politically, and to know how exactly the mechanisms that they are able to do this. Sorry for this vague answer. Maybe Zita can also provide some.
Thank you. I'm completely agreeing with Sefa about empowering spaces. So that I think a big part of the issue is that a lot of the spaces that are available, that are there for policy change, my first thought is Parliament, engagements with government departments, they are not spaces that are made inclusive of children's voices. And I think this is something that duty bearers need to be held to account to, right? And in addition, those of us who do engage in those sorts of spaces, who do have the privilege of being heard, should make sure that we bring children along, young people along, while we're making our voices heard. So again, one of the spaces I engage on quite regularly is the South African Parliament on issues of law and policy and anything related to that. And it's always our aim to say that the children who are impacted directly by what we're talking about, who do make, who do express their voices in different ways, also need to come and say, make their voices heard on these platforms, and then to put it on parliamentarians or duty bearers to say, you have heard what they are saying, what the youth or young people are saying here. How are you going to follow up with that? So it is my obligation as somebody who has some sort of influence in these platforms to say the young people have come along with us to make their voices heard. How are you going to take this forward and not just, again, make it a tokenism event? Again, sort of quite broad answer to a very difficult question.
Thank you both. I think those are very interesting questions because they kind of looked at the issue from two directions, right? So what the youth need to sort of empower them to become more politically involved, but also pointing out that these political systems were not designed with youth participation in mind. And so how do we rethink those systems to make youth participation easier? I think that's really fascinating. Aoife, I see you have a question. Would you like to pose the question yourself, or should I read it out?
Hi, Dina. Thanks so much. I'm just just trying to figure out. You'd think I would know how to work Zoom at this point. Hello, I'm Aoife from University College Cork. So I was just wondering, thank you so much to all the speakers. I've just enjoyed your talks so much. I've learned really an awful lot. I'm so grateful. And thank you to the organizers as well. I've just been so enjoying this over the last few days generally. But I was wondering, you know, I'm following a lot of the climate related litigation. I'm writing a lot about the climate litigation, and it's making so much ground. It's so exciting, but at the same time, a lot of it is not successful. Now, of course, the impact of it is not always in the success of the actual legal action itself. But I wonder, do you have any impressions in your work to the speakers, whether it you know, whether it may turn youth activists off their activism, or at least that legal side of the activism, because so much of it, you know, there was an EU case recently that is not successful. Now, some of it is. Some of it's of limited success. For example, in Ireland, the case in our Supreme Court was of limited success, but a lot of it has not been successful. So I was wondering if you had any experiences of that and youth reactions to that. Thank you.
Thanks, Aoife. Zita, do you wanna take a shot at that?
I mean, unsuccessful litigation could turn off anybody, because there's so much time and effort put into it, that when you don't get the result that you're looking for, it could be very demoralizing. But again, the thing with strategic litigation, impact litigation, is that that's not the end of it. So litigation is not a lone wolf, and I think we should always remember to, again, like I said before, bring youth along the whole journey. So not just litigation. So there's the advocacy that comes before the litigation, the advocacy and the lobbying that comes after the litigation, so that then young people are exposed to all of the work that comes into play in order to ensure slow systemic change. I mean, I think the other issue is that because the change that we're looking for is quite big and quite drastic, it's slow. It can be very slow. And so then it's also to remember, I think, to remind ourselves, to remind young people who are involved in litigation and anything else after that, that this is a long game that we're playing, unfortunately. And it does require us to keep going, to keep going with the flow, and to keep thinking through different strategies. And the litigation may be unsuccessful now, but let's work with the lobbying and advocacy and bring back the litigation later when you've got more information and greater reach, and then see how that works.
Thank you. That was really interesting. I'm very conscious that we are now well over our time limit. Although it's always hard to end these interesting conversations. But before we close off, I just wanted to see if either of our panelists wanted to say a last word or a last thought that they might want to contribute before we end. Maybe Sefa? No pressure if you've said everything you want to say on the subject.
I think I did say a lot of what I wanted to say. Just to maybe say that I learned a lot from the other speakers. It's difficult sometimes to advocate for yourself, especially when you don't consider yourself necessarily an expert in these topics. So learning a lot helps. And having access to this kinds of information does help young people advocate for themselves much more. And so, yeah, just a thank you to the other people on this panel.
Thank you, Sefa. Any last words, Zita?
Yeah, just excited about the prospects of all of the work that's coming up around environmental rights, whether it's related to advocacy, lobbying, litigation, research. Is all very exciting. And like I said previously, unfortunately, we're playing a long game. So things won't change now, but I think with persistence and people like Sefa pushing and making their voices heard, I think we're going to get very good outcomes.
Thank you. That's a great line to end on. This has been a completely fascinating panel. Thanks to Jonas, who's no longer here. Thank you, Sefa. Thank you, Zita. That was really interesting. We have recorded this, which I'm really glad about, because there's a huge amount I want to come back to and think about some more. Thank you very much to our audience. Thank you for your questions. We have another session just after this, which is, or sort of 1 o'clock this afternoon, which is connected in some ways. It's about business, human rights, and the environment, and thinking about business obligations to to communities, especially overlooked communities, is something that I think is very important. So check that out. And have a great weekend, everyone.
Thank you, everyone.
Thank you. Bye.